Research Associate at IMANI Africa. Hello, good evening, sir. Welcome to Eyewitness News. What exactly does IMANI want the Supreme Court to interpret in respect of the stated articles?
Hello, good evening, and hello to your listeners as well. So the name is Profi. What we sought to do with this writ to the Supreme Court was to take a look at how we can really safeguard and guarantee the tenure of public office holders. When you take a look at Article 191, which is on the protection of public officers, you realize that the Constitution itself tries to avoid the situation where public office holders are victimized or discriminated against while they are discharging their duty faithfully in accordance with the Constitution. What we've witnessed along the years, and probably 2-3 decades back, is the fact that whenever there's a change of government, you would see the new president appoint new public office holders in these category of public services. We know that the procedure for appointment is quite clear, that he has to do this in consultation with the Council of State. What is not really clear is how they can be removed. At least what we know by virtue of the Constitution is that, as you stated, there should be some probable cause, some justifiable cause, right? And so a list of the justifiable cause would include, like you mentioned, proven stated misconduct of that public office holder, a misbehavior which is established by law, and then when you have the state of incapacity, where the public office holder is not able to perform his or her functions by virtue of infirmity of the mind or body when he passes or when he retires or resigns. So these are the standards with which every president should meet in terms of removing public office holders. That is not clear, and then we are inspired to actually seek a declaration, interpretation from the Supreme Court, whether or not what we've been doing so far is constitutional.
I see, but how about a commonsensical approach in the sense that, these security chiefs are appointed by the president because the president should feel very comfortable and secure with heads of these agencies. If one regime appoints a security head, leaves, and this security head remains, the concern really is that the other person or the person occupying the position would hold allegiance or loyalty to the president whose tenure had just ended, or the outgoing or outgone president. Shouldn't that be enough concern for you? Because it appears, or it does appear, that is the concern, and that is the reason why the practice has been so.
Well, unfortunately, without respect, that very point is moot, because when you take a look at the public service itself, it's supposed to be non-political, right? So the very fact that you want public office holders to align with your political ideologies is neither here nor there. In fact, when you take a look at Article 296, which sort of spells out the exercise of discretionary powers, even those powers which are attributed to persons who are qualified to act as such should be clearly spelled out and should be published for everybody to know that these are the procedures in which, in the context of my exercise of discretionary powers, this is what is expected of me, so that we don't leave anything to chance. When you leave things to the personal opinions, like you said, if it's by common sense, that there won't be the clearly spelled out procedures by the Constitution, which we are all encouraged to follow.
But the history is also important in interpretation. So in the past, we've had General Ankara and Hale. Hale was one of the top guys, or maybe the IGP at the time, and they masterminded a coup d'etat. And so, given that historical antecedent, it kind of makes presidents or leaders of the country now quite paranoid about persons who occupy key positions. Shouldn't that historical fact play on your mind whilst you go to the Supreme Court to seek this interpretation?
Well, I believe that the dictates of the Constitution should actually trump every other consideration. Again, if you leave things to what we think and what we feel and what we believe should be the case, then we're going to have multiple layers of opinions, which and it's going to be quite murky. What we need to do is to follow what the Constitution says. If it's in the letter and spirit of the Constitution to say that, well, there should be some justifiable cause before their removal, then there shouldn't be any excuse to that effect. Why is it that when it comes to the appointment, we just are willing to follow what the Constitution says, but not the removal? You have in instances which you clearly listed in the writ of persons who have been removed prior to their retirement age, with no reason at all given them. This is in clear, we believe, in clear breach of what the Constitution says, and and that's why we think the Supreme Court should really give an interpretation to what is expected of us moving forward.
I see. I want to thank you so much for the opportunity to speaking to you. Of course, the matter is in court, so we'll hold it here and await what the Supreme Court says in respect of this particular matter. Eyewitness News on 97.3.